case to come before the court is State versus Purk. Counsel ready? Each side will have 15 minutes to present their arguments to the court, and the appellant may reserve up to 5 minutes.
Thank you, Madam. Good afternoon. May it please the court, I'm Jack Corgan, and I represent the appellant in this matter, Mr. Scott Purk.
You hold on just 1 second. Can everybody hear counsel? Not really?
Is the mic on? How about now?
Should line up the red if it's on.
Okay, we're on now.
There we go.
Okay.
No? We can share.
Thank you, Judge. Can you hear me now? Okay, good, thank you. Okay, may it please the court, now that we've finished the Verizon commercial of the day. We're here because my client, Mr. Purk's first wife, Meg, died in 1985, and 28 years later, my client was accused of murdering her. He challenges his conviction for his wife Meg's death for 4 reasons. First, that the 28-year delay between Mrs. Purk's death and Mr. Purk's indictment violated his due process rights. Second, that allowing testimony by the medical examiner that was based on unreliable experiments violated Mr. Purk's right to a fair trial. Third, that the state withheld evidence from Mr. Purk's trial attorneys, evidence that they could have used during cross-examination, and that this deprived Mr. Purk of a fair trial and violated his due process rights. And fourth, that Mr. Purk's conviction is against the manifest weight of the evidence. With the court's permission, I would like to focus my argument on the first 3 assignments of error, submit the 4th assignment of error on the briefs, and reserve 3 minutes of my time for rebuttal. Again, in his first assignment of error, Mr. Purk takes issue with the 28-year delay between his wife Meg's death and his indictment for her murder. Mr. Purk's case meets both parts of a 2-part burden-shifting test that applies to delays like this. First of all, he can demonstrate that he would actually suffer actual prejudice because exculpatory evidence was lost due to that lengthy delay between the time of Meg's death and the time of his indictment. And second, he can show that the state can't demonstrate that its delay in indicting my client was justified. Now, to meet that first prong, Mr. Purk can show prejudice because evidence that was critical to his case was no longer available by the time he came up for trial. Now, when Meg Purk died, my client had told officers that he had found her hanging from a stairwell banister in their apartment. And the police officers took photographs of the scene, including the apartment. They took a sample of the rope that was around her neck. And there would, at the time, have been medical records from some of her treatment. Mrs. Purk had a history of suicidal thoughts and suicide attempts. And there was a history of her being treated at what was then the Fallsview Psychiatric Hospital in Cuyahoga Falls. And she had some treatment history there.
Counsel, let me interrupt you just for a second. In regard to, I know that there was testimony about the prior suicide attempts and so forth, but I was a little confused in reading the briefs about the treatment at Fallsview. How is it in the record that there was treatment? Because I know one of the allegations is that Fallsview records were not available anymore due to disclosure and just not available.
If I'm recalling the transcript correctly, and it was a lengthy transcript, as you know, I believe that there was testimony by one of the police officers that he had talked with Mrs. Purk's mother, who had confirmed that Mrs. Purk had sought suicide. And had those records still existed at the time when Mr. Purk actually went to trial, it could have helped his case, because his argument was, my wife committed suicide, I didn't kill her. And so the treatment history that she had could have shown what her state of mind was or could have been at the time when she actually died.
Well, counsel, how long ago was that Fallsview treatment?
That was even longer ago than 1985.
Well, in which way would it have reflected on her state of mind on the day of her death?
Well, looking at the testimony from her friends, from her brother, from, through the police officer, her mother, who was not able to testify, she had a long-term history of having suicidal thoughts and depression, suicidal ideation, dating back from when she was a teenager. And sometimes she would make an attempt where nobody seemed to have any prior idea that it was going to happen. For instance, her best friend with whom she had lived prior to her marrying Mr. Purk came home one day and found a suicide note, or not necessarily a suicide note, but a note from Meg Purk indicating that she had attempted to hang herself from a cord from the Venetian blinds in their apartment. And the friend had no idea prior to that she was thinking about suicide or was in that kind of state of depression. And so,
I'm sorry, I want to ask you a question about that. Because I'm unclear from reading the briefs, and I want to be sure I'm clear about this. Was evidence of her prior suicide attempts or suicidal ideas, opposite of that, did that come before the jury, or was it precluded?
a lot of it was before the jury.
Okay.
There was one piece of evidence that the defense was not able to get in, and that was the defense wanted to ask one of the officers who had actually been at St. Thomas Hospital when Mrs. Purk was brought into the emergency room. There was an idea that the nurses who treated her at the emergency room had said, she's done this before, meaning she's come in with having attempted to commit suicide. And that was the piece of evidence that the jury did not hear. The rest about treatment history at Fallsview, the friend, Dawn Cracker, testifying that she tried to hang herself from the blinds, that was in front of the jury. But the records from Fallsview would have presented a bigger picture, would have presented a more complete picture. Because the state's argument was, Mrs. Purk was almost ready to give birth at the time when she was found hanging. And why would she attempt to commit suicide when she was that close to giving birth? And yet the records from Fallsview could have given light to her state of mind and the kinds of patterns that she might have had. Also, her records from her treating physician may have also shed light on that. The police had attempted to find the records from the physician who was treating her during her pregnancy. And the doctor had passed away. His wife made a valiant attempt at trying to find the records, and they'd already been destroyed. So those treatment records where she might have told her doctor what her state of mind was through the pregnancy would have been helpful. Those were the kinds of things, as far as her medical records, that would have been helpful to Mr. Purk's defense. In addition, the photographs that the Akron police officers took at the scene would have been helpful to the defense, because it would have shown Mrs. Purk and how she had, or what the arrangement was with the rope from which she was found hanging, and how that actually had worked. The rope itself also would have helped, because it would have demonstrated whether it could have caused 6 small marks that were found in the second autopsy. lot of the recollections of her friends. Even John Cracker, who did testify, there were a lot of things that she had told police officers that were in their reports of investigation that by the time we came to 2015, she could not recall. She couldn't recall telling officers many of the things that she had told them back in 1985.
How would you respond to what I'm sure the state's argument will be, that this is all speculative, what might have been shown, faded memories?
Well, the faded memories go directly to what's missing. The faded memories are what's missing. When they're relevant to the defense, when they could have shown, when they would have minimized or eliminated the impact of the state's evidence and helped to bolster the defense, that's when you have actual prejudice.
But isn't there a case law that faded memories do not, that type of evidence does not equate to prejudice?
There is some, but what we're looking at is instead the totality of all the evidence that was missing here. With, like I said, photographs that were taken, the rope itself.
Wasn't there a similar rope that was a rope that was admitted into evidence, that there was testimony that this is consistent with the rope that existed at the time of the incident?
It's consistent based upon the recollection of the officer. Still, the best evidence would have been the rope itself. Because that, even though ropes may be similar, it doesn't exactly show the precise way in which a rope or anything else may have left any marks on the body of Mrs. Purk.
Counsel, let me ask you a different version of that question. Her death was ruled as suicide. Many years later, subsequently, your client was convicted of her murder. If what happened at that residence was so convincing to convince a coroner that it was a suicide, presumably because of what your client did, how does that become the state's fault? The delay. How does the delay become the state's fault?
Well, because except for what I've just told you was missing, the state has based this prosecution on the exact same evidence that was available to it in 1985. And the state can't show that that delay is justified. We actually, like I said, we have the same evidence but less. So, the Akron Police Department stopped investigating this case in 1985 based on the coroner's ruling, not based on anything that my client had done. And when that delay, or when the state has compiled evidence but simply fails or refuses to take action for a substantial period, the delay is not going to be justified. And that's from the State versus Walls case from 2002. You can't just sit on the same evidence and wait and wait and wait. It's very similar to the doctrine of latches in a civil case. If you wait too long to the point where the evidence goes stale and you wind up hurting your other party, your opponent.
Counsel, you're up.
Oh, thank you.
If you want to say your rebuttal, that's okay.
I would, thank you.
All right, thank you.
May it please the court. Heaven DiMartino on behalf of the state of Ohio, the appellee. We are asking that this court affirm Mr. Purk's convictions for murder as well as tampering with evidence in the death of his wife and their unborn child. Returning to the first assignment of error that was raised by defense counsel, the state would just take a minute to note that this case originated 30 years ago. It was ruled a suicide at that time. Most of the people who responded to the call, fire personnel, emergency personnel, had never been to a call such as this. So this was very abnormal in that you had a 9-month pregnant woman ready to give birth. The husband's statement was that he found her hanging topless after he had been in the bathtub for a few minutes. So everything about this scene was very unusual. The fire personnel, medics that testified 30 years later were able to recall The evidence that was obtained at the time of the investigation led to a medical examiner's report that this was a suicide based on the fact Dr. Dean as well as Dr. Halsey testified that the problem with the original autopsy is that the hyoid was not removed. You have to remove the hyoid to see if there's certain type of tearing, which definitively can show the difference between a hanging, a suicide, or a strangulation, or murder. So to say that the state had this exact same evidence since the death in 1985 is untrue. What the state had was a situation where a husband preyed on the fact that there were allegations, rumors, etc., that Margaret had prior suicide attempts or threats. Certainly there's evidence that she had made threats to commit suicide, and her murder was framed in such a way that it looked like a suicide. And when you have a medical examiner who conducts a autopsy without doing one very important piece of that autopsy, you're left with a case where it was ruled a suicide, and it stayed that way for 28 years until another officer happened to be talking to Mr. Purk on a call regarding a fire, and Purk made some comments about his wife dying in the apartment where they lived. And that caused the state to reopen the investigation. But to hold the state responsible for the delay between the death and the indictment is so disingenuous in this case, because the very reason why the evidence was not available to the state at the time of the murder was because the defendant created a situation where it appeared that there was in fact a suicide rather than a murder.
Except that, counsel, you just mentioned that the first autopsy was incomplete, basically.
It was
So if it
incorrect.
was done correctly, you would have, in your opinion anyway, have determined that it was a murder at that point.
Perhaps. An autopsy in 1985, I don't know if that was the protocol to have removed the hyoid bone. Certainly by the time Dr. Dean looked at it and Dr. Halsey, current protocol would be to remove the hyoid. So,
Counsel, would you add to that the fact that back in 1985, you had a suspicious detective, correct?
very much so, and that was the other part of it, is that once the officer had spoken with Mr. Purk 28 years later, he went back and talked to the officers who were at the original case, and they did find it suspicious. They just did not have the evidence at the time. And you're talking about a long time ago when, our evidence collection wasn't as good as it was. The research wasn't quite the way it was. There were not as many cases available for officers to look at as far as, strangulation versus suicide attempts. So we're kind of taking, a kind of an older case, bringing it forward in time to a time that really doesn't equate to when the crime occurred.
I'm not aware of whether or not the prosecutor back in 1985 could have directed a second autopsy or guided the coroner's office as to further testing that they may have wanted to be done. What was the situation back then?
There's nothing in the record one way or the other as to whether the prosecutor could have done that, whether the prosecutor wanted that. The fact is that all of the people who responded to the scene had never been on a call like this. They just kind of didn't basically have the experience to say, wait a minute, maybe this is actually a strangulation being covered up as a suicide. So they had what they were presented with. They had that autopsy result. And even though they had questions and concerns, they let it go with that. With regard to the idea that the evidence was exculpatory and is not available, and therefore, the defendant meets the dual prong of the luck test, the state would argue that there is no evidence that the defendant has shown that is anything more than speculation. The evidence that was taken, the pictures, the rope that was collected, all of those things are in the record as far as photos. There are medical testimony that the injuries that were on her neck were consistent with the rope, that the injuries across her chest were consistent with the rope, that it was consistent with her being dragged after she was strangled. So all of those things are in the record. The fact that we didn't have that piece of rope doesn't change the evidence that is in the record. As far as the my recollection is there was nothing definitive to say that she had even been treated and that there would be records. And even if they were, if she had made a prior suicide attempt, especially something along the lines of a hanging, that would actually help bolster the state's case that this is exactly what Mr. Purk was trying to do, was kill his wife and make it look like it was a suicide attempt, just like people would expect if she truly had that ideation. The other thing is this, Ms. Cracker and other friends and family testified that, to the contrary of what was stated here today, that actually Margaret was very happy and looking forward to having this baby, and had written poetry, and that there was no indication that she was anything other than looking forward to the birth of her child within just a few days. As far as the introduction of the testimony of Dr. Dean, there was no error when the trial court admitted the testimony of Dr. Dean. So Dr. Dean was the current medical examiner who ordered that the body be exhumed and conducted a second autopsy. And her testimony as far as the cause of death and her autopsy findings were based on her examination of the body. She did confirm her findings by conducting reenactments, both with a fireman's dummy, I believe it was, hanging from the staircase in the apartments, which had not been redone. She also conducted some reenactments with skin by using clay, and those reenactments confirmed her beliefs, but they were not what she based her beliefs on. Therefore, that type of demonstrative evidence cannot be said to have been any type of an error. That is reviewed on an abuse of discretion standard. There's nothing in the record here to show that the trial court abused its discretion by allowing that evidence. And in fact, the evidence that was shown on the clay, it was very helpful, but it was nothing more than demonstrative assistance. The trial court did not violate Mr. Purk's due process rights by keeping out emails between Dr. Dean and the state's second expert, Dr. Hawley. The defendant tries to argue that this is a Brady violation, when in fact it's something that should be examined under the discovery rules. The trial court looked at the emails, found that they were work product, and then kept that evidence out as work product. So if counsel wants to argue about the content of the emails, it should have been raised as a violation of discovery, and saying that the trial court erred in determining that the content was work product. As it stands now, you have the trial court's finding that it was work product between two professionals looking at an autopsy. Nothing more, nothing less. And finally, as far as the manifest weight of the evidence showed that on March 18, 1985, police and fire went to the Timbertop apartments where they found Margaret Purk, 9 months pregnant and full arrest. She had a rope that was around her neck that Mr. Purk said he had cut down. The reenactment showed that if that happened the way he said, that slip knot would have come off, but yet it was still hanging there. Purk identified the rope, said that it was his. The rope was removed at the hospital. It was taken into evidence. The evidence was that Ms. Purk was days away from giving birth and was looking forward to the birth of her child. We fast forward to 2009 when Sergeant Mifflin talked to Mr. Purk. The suspicions were once again raised that could be a murder as opposed to a suicide. Talked to Dr. Dean, who ordered that the body be exhumed. And looking at her findings, she found some issues with the autopsy that was conducted by Dr. Ruiz, including even-sized dots on Ms. Purk's neck, bruising on her face, bruising on her chest, and also the hyoid bone had hemorrhaging around it, which is indicative of being strangled. So everything that Dr. Dean and Dr. Halsey were able to put together after they reopened the investigation was consistent with someone who was strangled, not someone who had committed suicide. And if there are no further questions, I would rest on my brief.
Thank you.
Thank you, Your Honor.
Yeah.
Thank you, Anna. Just a few points. First of all, just to clarify, Mr. Purk was never charged with the death of his child. Second of all, as to the state's argument about Mr. Purk being responsible for the supposedly hiding the evidence of his wife's death, the only difference, the only thing that changed in the 28 years between the time that Meg Purk died and the time when the state began prosecuting my client was a difference in the opinion of the medical examiner. We cannot hold my client responsible for any lapse by the medical examiner from 1985, if that's what occurred. Okay, the state is essentially saying we have a better autopsy today. Well, we can't hold my client responsible for the fact that we have an arguably better autopsy today.
Quickly, how's this different from the rape cases where the DNA is discovered years and years later and a prosecution is wrong?
Because you don't have the identity of a person in those cold rape cases. You have to test the DNA and find out who the actual defendant is. Everything that upon which my client was prosecuted now was known to police and known to the state in 1985. There was Mrs. Purk and all the evidence that her body comprised. There was the rope, there were the photographs, there were the medical records, there was the actual physical scene itself, and they also had the identity of my client. In the cold case rape cases, we have to test the DNA using new technology just to find the identity of the suspect. And I think that's the most important difference, Your Honor. But instead, like I said, the only difference that we've had here in this case is a differing opinion by a differing medical examiner. Yes, Detective Luer was suspicious of my client back in 1985. It wasn't like a new creation on the part of the state. Detective Luer could have acted on that suspicion even in 1985. There was, other than the new autopsy, there was no new actual evidence collected. In fact, what we have is less evidence because evidence has been destroyed, memories and evidence have been degraded. And the medical testimony in this case is not necessarily uncontroverted. The defense did bring in its own expert to show and to testify that the injuries, the other injuries on Meg Purk were not caused by anything my client could have done, not caused by a roller. Thank you, and I ask you to reverse.
Thank you. Thank you both. Thank you both for